Hello, everybody, and welcome back. If you are a panelist for this section, which is class 8, could you please turn your video on? Okay, I think we are waiting for Mr. Rakeful. And meanwhile, we will go ahead and introduce ourselves. And we just had him for the last panel, so I have no doubt he will be back. But we will start from the government side. So I'm Reagan Smith, General Counsel of the Copyright Office, and I will ask my colleagues and to keep time short because we are a little pressed. We will go Ms. Chauvet, Mr. Gray, then Mr. Bartelt. Please introduce yourself.
Hello, I'm Anna Chauvet. I serve as Associate General Counsel.
Hi, everyone. I'm Mark Gray. I'm an attorney advisor here in the Office of General Counsel.
Nick Bartelt, also an attorney advisor in the Office of General Counsel.
Thank you. Mr. Cheney?
Stacy Cheney, a senior attorney advisor at NTIA.
Thank you. And now we will ask those who filed in support of the exemption. So going alphabetically, Mr. Band, Mr. Lennon, and then Mr. Reed. And when Mr. Rakeful joins us, we will acknowledge him.
Hi, I'm Jonathan Band, representing the Library Copyright Alliance.
Hi, my name is Gabriel Lennon. I'm a second-year law student with the CU Law Samuelson Glushko Technology Law and Policy Clinic, working with Professor Reed.
And Blake Reed for the clinic. We're here on behalf of ACB, doing our best to track down where Clark went. But I think given the issues that are at play, we can proceed. And before we do, just wanted to extend our thanks to Rachel Counts and Megan and the others on the Copyright Office and library staff for all of their help in organizing the hearings today.
Thank you. I should second that. I think I'm very proud of the work that Rachel and Megan and others on our team did, but also our Office of Public Information and Education, as well as in the broader library. So thank you for recognizing and because there's a lot that is unseen that goes into this. So Ms. Castillo, could you please introduce yourself?
Yes, my name is Sofia Castillo, and I'm with Mitchell Silverberg and Knoop, and I'm here representing the joint creators and copyright owners.
Okay, so I think with Mr. Reed's suggestion that it will be okay to start, and this is the last hearing, so if Mr. Rakeful joins a little bit late and we have to go a little bit over, we'll be able to make sure we hear from him. We will get started, and I think it is you, Mr. Gray, as the first question.
Yes, that's right. So my first question is for Mr. Reed. There was some conversation in the comments about using the term phonorecords in the text of this exemption for the modification. And the joint copyright owners comment wanted clarification about whether this would cover sound recordings of performances of musical work. And our understanding from your reply is that you were just trying to track the changes to section 121. So if we at the office, for example, regulatory text actually stated for purposes of the exemption, phonorecords as a term does not include sound recordings of performances of musical works, would that be a reasonable thing to include in the regulatory text?
Thank you, Mr. Gray. If I could, I'll defer to Mr. Lennon on this one.
Thank you for the question. So it is our understanding that the inclusion of the term phonorecords in section 121 and 121A does primarily aim to clarify that audiobooks and similar oral recordings of covered literary works and musical notation can be remediated into accessible formats and distributed under section 121A and imported and exported under section 121A, excuse me. So from our perspective, given that the inclusion of the term phonorecord is intended to reflect the Marrakesh Treaty, and the driving purpose behind our interpretation of the term phonorecords is to clarify that audiobooks and oral renderings of covered works are covered under the exemption. I believe that would be a reasonable addition.
Great. And Ms. Castillo, would that address the concerns from the joint copyright owners comment?
No, I think we are essentially in agreement, but I think our concern is mainly that the term phonorecords is traditionally associated also with sound recordings of musical performances. And so the Marrakesh Treaty does not cover those works. The phonorecords that are covered by the Marrakesh Treaty are those that contain literary works and previously published musical works that have been fixed in the form of text or notation. So we realize and we agree that the term phonorecords does appear in sections 121 and 121A as a result of the Marrakesh Treaty Implementation Act. But we believe it is important to make the distinction here that phonorecords containing sound recordings of musical performances is not covered by the exemption because individual eligible persons will rely on this exemption to engage in circumvention. And those individual eligible persons may or may not be fully familiar with the scope of the Marrakesh Treaty and that it's limited to literary works and musical works in the form of text or notation. So that is where our concern is coming from and why we think that it is worth including that clarification in the regulatory language.
Okay, yeah, sorry, Ray, you can go ahead.
Sorry, I just wanted to make sure, because I may be less close to the record, but have you provided alternate regulatory language that you do support in your comments?
We have not specified regulatory language in our comments, but we are happy to provide it in a subsequent letter if that would be helpful.
Thank you. I think we will be in touch if we determine that will be helpful. So thank you. Okay, sorry, Mr. Gray.
Okay, thank you. And then to stay with Ms. Castillo, there was a conversation in the comments about whether or not the import and export of accessible copies under section 121A is sufficiently distinct and attenuated from circumvention activity to implicate section 1201. So the joint creators have a position on sort of the interpretation of whether the activity from 121A specifically addresses or implicates the section 1201 right.
We do not have a position and we're not opposing any of the other proposed changes we're actually not opposing any of the changes proposed by proponents. We're only asking for the clarification about the use of the term phonorecords and that it doesn't apply to phonorecords of sound recordings of musical works, of musical performances, sorry.
Right, and so when you say you aren't opposing any changes, does that mean you don't believe there needs to be a new showing of adverse effects for the modification here, or that you don't object to the adverse effects showing in the proponent's submission?
Can you repeat the last part of your question, please?
So does that mean that there are no objections to the adverse effects showing an argument made in the supporting comments for this class?
Yes, yeah, we have no objections to that.
Okay, great. Don't see any hands raised, so I think we're still good on that. The next question is for Mr. Reed. You've proposed to update the beneficiary language to just say eligible person as defined in section 121. Could you just briefly explain, on top of the written record, why this expansion is necessary and why the failure to include that in the new language would create adverse effects for non-infringing use?
I'll defer to Mr. Lennon on that one as well. I did want to just quickly respond to Ms. Castillo on the last one. We took the concern to be that there would be circumvention of digital rights management, or that an improperly broad construction of phonorecords of musical works could be read to cover audio files from streaming music services and that sort of thing. And I did want to clarify, I don't think that's what we were going for in asking for this exemption. However, we do want to be careful not to narrow the scope of section 121. Obviously, this exemption for the last several rulemakings has tracked closely the scope of 121. Perhaps Mr. Band or others can speak to the reason that phonorecords was used in section section 121, we do want to be careful that when we're thinking about the expanded scope of 121 to musical works that are in text, that there may be creative ways that folks use to make musical scores accessible that don't encompass a performance of the work, that are not a sort of a sound recording of a set of musicians actually performing the work, but nevertheless allow a person who is blind or visually impaired, and the sort of thing might be reading through voiceover or similar technology, musical notation or guitar tablature or something like that. So we do want to make sure that the exemption doesn't carve out the ability to make accessible transformations of musical works that are reduced to text. I'm sorry, I wanted to make sure I tagged that before we moved on. I can defer to Mr. Lennon to respond to your question.
Thank you. So we're discussing the expansion of the term blind or other person with a disability to the new language in the Chafee Amendment, which is eligible persons. So the personal use portion of the exemption currently points to a definition of who is covered in section 121A that no longer exists. With that update to eligible persons, we have laid out a more expansive definition, which actually covers more disabilities than were previously covered under the old pre-Marrakesh Treaty Implementation Act language. So now those with disabilities who are covered are those who are blind or have visual impairments or perceptual reading disabilities, as well as physical disabilities that affect the ability to manipulate a book or move or focus the eyes. So we believe that this expansion is necessary to not only comply with the updated terms of the Chafee Amendment, but to provide access to those who maybe previously were not qualified under the old language of the exemption.
Okay, and then I guess next question we have is sort of similar. So there's also a proposal to update the non-dramatic literary works limitation to now apply to all literary works and previously published musical works fixed in the form of text or notation. Can you also, kind of same question, explain why this is necessary, and then B, why, if we didn't adopt that language, there would be adverse effects on non-infringing use?
I'll defer to Mr. Lennon on this one as well. Just also wanted to add regarding the previous one that the mechanics of certification that were previously required under 121A and its interaction with the Pratt-Smoot Act are no longer operative. And we think the ability for people with disabilities to self-certify as opposed to having to go seek a formal certification from a medical provider and so forth to be eligible for that portion of the exemption is important. Hand it off to Mr. Lennon.
So as it stands, section 1201A1's prohibition on circumvention is an impediment to access for people with print disabilities to previously unavailable copyrighted works, such as stage plays, screenplays, and notated musical works, which are now within the scope of works contemplated in the post-MTIA language of section 121. So under the changes made by the MTIA, the scope of eligible works covered under 121 has been meaningfully expanded. And thanks to the anti-circumvention provisions of 1201, necessitates that this exemption be revised to provide eligible persons access to these new areas of permitted works. And I think it's important to consider not only screenplays, but again, sheet music and music fixed in the form of text or notation is not something previously covered under this exemption. And that is essentially an entirely new area of accessible works. And I think it's important to recognize that opportunity.
Ms. Castillo, you have your hand raised.
Yes, I would like to briefly address Mr. Reed's concern with the potential for narrowing the scope of Section 121. During the legislative implementation process for the Marrakesh Treaty Implementation Act, back in 2016, the Department of Commerce sent a statement of purpose as part of its legislative implementation documents. They sent a statement of purpose to then Vice President Joe Biden, where they explained what the necessary changes would be to the U.S. Copyright Act in order to comply with the Marrakesh Treaty. And in that statement of purpose, they made the express distinction saying that sound recordings of musical performances were not included in the Marrakesh Treaty and were therefore not included in the changes made to Section 121 and 121A.
And then, Mr. Reed, to kind of follow up on that point, you were talking about creative ways of creating sound recordings that might be more accessible, but not quite be just a pure recording of musicians performing a work. But in the context of this, we're talking about circumventing a phono record, and so is your concern about narrowing that there might be pre-existing phono records that aren't quite sound recordings of performances that might need to be circumvented, or are you thinking about sort of post-circumvention accessibility, like the output of that process?
I feel like I might need to tap on Mr. Band as an older copyright hand on the distinction between reproductions, copies, and phono records here. I guess the concern that we have is, when we're talking about copies or phono records of the literary work or of musical notation that's been reduced to text, we want to make sure that we can get access to the underlying either text or the underlying musical work. And we want to make sure, if we cut phono record out of that, I understand phono record has a quite specialized definition, but that we're not talking about cutting out the underlying work, if that makes sense. I don't know, Mr. Band, do you have any additional thoughts on this one?
No, it's just that, copies by itself is not sufficient for precisely the reasons Mr. Reed indicated, that it's the statute does talk about copies and phono records, and they each cover different things. And so we need to, now obviously in 121 and 121A, they use phono records, but it's not all phono records. So it sounds like this is just a drafting issue, that there's, I don't believe there's any disagreement in principle here.
So based on what the proponents have put forward in terms of proposed regulatory text, we would need to do any sort of additional modifications to address the question of phono records beyond maybe the clarification of sound recordings of musical work performances. Is that right?
I think that's right. Yeah.
Yeah, I think so too.
We three agree.
All right. Well, that's great to have agreement. If no one has any more responses on this question, you have another. So for Mr. Reed, you also proposed replacing the language about the price of quote unquote mainstream copies to just the market price of an accessible copy. We understand your statement in the written comments on why that's necessary, but could you elaborate a little bit more, just for the record here on this transcript, about why this change is necessary as well?
Thanks, and defer to Mr. Lennon on that one.
Thank you. So we believe the office should recommend the replacement of the phrase mainstream copy with more inclusive language, such as you say, inaccessible copy. The term mainstream copy reflects a troubling ableist framing that sort of reinforces a damaging and frankly offensive conception of people with print disabilities by casting books in formats that are accessible to them as not mainstream. So that an exemption from copyright law is required for people with print disabilities to legally access accessible literary material that is available to people without print disabilities is essentially a tacit recognition that people with disabilities are routinely treated as second-class citizens, to put it frankly, by the publishers of books. So in the text of the exemption itself currently reinforces this ableist notion that people who have print disabilities are outside of the quote mainstream. And if that language is not updated, the exemption itself will perpetuate harm, even as it helps those with print disabilities gain access to accessible works.
I might just add, if I could, Mr. Gray,
Sure.
I think this is an opportunity for the office to convey a vision that indeed a mainstream copy of a work is an accessible one, not an inaccessible one. And I think that's a theme that we've underscored, and that the groups that have advocated for this exemption have underscored in previous rulemakings, that the goal here is for every copy of a book, for every copy of a piece of musical notation to be accessible and to be born accessible. And that when we're talking about mainstream, we're actually talking about a version of the work that's accessible right out of the gates. Thanks.
Great. And so that, I think, actually answers the questions I have. I do want to give a chance for Mr. Sheeny to ask any questions he has from the NTIA side.
Thank you, Mr. Gray, and I appreciate those questions. Those were great questions for us today. Mr. Reed, I have a question for you. And this goes to the definition of eligible person. It looks like to me that this sets a parameter that might be not all inclusive. I know you've expanded the definition from the last time, but can you speak to that? Can this be a floor rather than a ceiling in the definition of what you've set here? So you've set it according to 121, but can we in this proceeding expand that further? And is there room for that in what you guys talked about?
Thanks, Mr. Cheney. I'll take a quick stab at this one, then Mr. Lennon, if you have any additional thoughts. I would say what we've tried to do with this exemption is tack pretty closely to the compromise that's been struck in going back several rulemakings to have this exemption tied pretty closely to the machinery of Section 121, at least for the authorized entity provisions. And so the reason we scoped the request the way that we did in terms of the types of disabilities that are covered, it owes to the changes that the Marrakesh Treaty Implementation Act brought to Section 121. But to your point, obviously, as we talked about in the last hearing, there are a range of disabilities that go quite far beyond the disabilities that are teed up even in the modified version of Section 121, excuse me. Obviously, we would think the Americans with Disabilities Act sweeps quite a bit broader than that as amended, and that other disability laws sweep quite more broadly than that. And the reason we brought Class 17 and that we proposed Class 17 was to encourage the office to consider that broader range of disabilities and frankly the broader range of copyrighted works to which those categories of people with disabilities that are not represented in this exemption see themselves represented here. To the extent that the office sees fit to expand this class of works to accommodate some of the additional classes of disabilities, we think that would certainly be appropriate. We wouldn't have any objection to that. I would just underscore the case that we made in the last hearing, which is that we think there's a much broader class, our set of copyrighted works that need to be covered beyond the rather narrow subset that's covered in this exemption.
Thank you, Mr. Reed. And to follow up on that and some of the questions from the last hearing, if the office concluded that it would be less confusing or otherwise beneficial to have just one exemption for literary works for accessibility as opposed to in two places, I hear the suggestion that perhaps instead of just tracking to 121, either explicitly including a reference to the ADA, perhaps other state laws, if I'm going to draw some through lines throughout the day of testimony. Are there any other specific suggestions that you would offer with respect to this exemption?
Ms. Smith, if I could ask a clarification, do you mean specific questions just on kind of where Mr. Cheney started us off on the class of people with disabilities that are covered?
I think it is building on what Mr. Cheney said, as well as just for uses of literary works to make them accessible generally. So that might be a little bit broader than what Mr. Cheney said.
So I will do my best to respond. And I would say, I think it's actually somewhat helpful to have the exemption as we have it framed here for ebooks. It's quite specific and it's narrow in its scope, but it does provide a fair bit of just as 121 and 121A are, there are a range of specific requirements and limitations attached to it. For the kinds of people with disabilities and the kinds of organizations that are included within Section 121 and Section 121A, having a specific exemption, and by the way, we should point out also that Section 121 actually extends, I think, probably beyond the bounds of fair use in its allowance of the provision of works without remuneration to the rights holder by an authorized entity. And that's obviously a kind of a historical feature of the Chafee Amendment that dates back to the Pratt-Smoot Act and the American Printing House Act. It's helpful to have that very specific exemption on which a lot of organizations rely on to sort of make clear that that's a specifically known category of acceptable both circumvention and remediation and import and export. It kind of gives a blueprint, a set of instructions for that. The reason we ask for the other exemption is to extend out to the bounds of fair use, but we recognize that the bounds of fair use can be a little bit less clear and a little bit less sort of prescriptive and have fewer obvious limitations that have got to be sorted out by courts after the fact. So I actually think it makes sense to keep the specific exemption in place for this, just because it's such a kind of known quantity for the organizations and people that operate in this space, and to explore expanding beyond that with a more general exception that looks more towards fair use, if that makes any sense. I don't know if Mr. Band has anything he'd add to that one.
No, I agree. It just reflects the general attention that, or not necessarily tension, but that specificity is good and generality is good. So we like 108 and we like 107. And so, they each have their time and place. And so, assuming that there's enough pages in the CFR to accommodate both specific and general, then we would welcome that.
Yes, well, as long as we pay for it, there are pages in the CFR. But I appreciate that response. I think the Copyright Office is, obviously we have supported 108 reform, independent of looking at 107 and the important work that it does. So I think those are all of our questions. So we are perhaps able to wrap up a couple of minutes early, unless anyone else would like to say another comment for the record. If you do, please unmute yourself. And I'll just, yep, go ahead.
I just wanted to convey to Ms. Castillo and her colleagues our appreciation for again the spirit of cooperation on this exemption and for being amenable to the changes that we've proposed. Appreciate that.
Thank you, Mr. Reed. We're happy to work together wherever we can.
Okay, so this will conclude today's hearings. I just want to give the audience members 2 reminders, as well as, I guess, the panelists. For one of them, there will be a different link tomorrow, which will be Class 1, which is use of audiovisual works for criticism and comment. So that is available on our website if you wish to watch the proceedings tomorrow. And secondly, if anyone wishes to sign up for the audience participation session, there will be one this Thursday, as well as one April 21st at the conclusion of all of our hearings. Please go ahead and fill out the link, which I believe has been sent in the chat. Yes, it was sent at 2:30. So thank you very much. And we will convene again tomorrow at 10:30 a.m. Eastern. Thank you.